SJC-13030, Kathleen Hornibrook v. Cheryl Richards.
Attorney Kelly. Good morning.
Good morning. Good morning, and may it please the court. My name is Kristen Kelly, and I'm here with Alan David, and we represent the defendant appellant Cherilyn Richard. Now, the issue before the court this morning is whether a court-appointed conservator is entitled to absolute quasi-judicial immunity for claims where it is undisputed that with respect to all allegations in the complaint, that the conservator was acting within the scope of her court-appointed duties. Now, briefly, this matter arises between a dispute between Kevin Hornibrook, who is his mother's court-appointed guardian and the eventual personal representative of her estate, and Cherilyn Richard, who is Kathleen Hornibrook's court-appointed conservator. The main premise of this dispute is that Mr. Hornibrook is seeking to hold Ms. Richard personally liable for tort damages for actions that she indisputably took in her scope of appointment as a conservator. For example,
can I clarify?
Excuse me, counsel. Oh, go ahead.
Go ahead.
I was just going to ask you, counsel, can you please let me know, are you alleging that all the actions were within the scope of the duties of a conservator, and that's the only issue we have to conclude? Or are you arguing that if they were outside that action, we need to address the liability question?
my position is that in this case, all of the actions were within the scope of the
Right.
appointed.
Of the conservator.
Yeah.
And now, are you also suggesting then, we kind of, when we look at the immunity issues, we take a functional approach, correct?
Absolutely,
So how
yes.
does that affect the issue of immunity in this instance?
In this instance, in the case, I don't think there is an issue with respect to whether the actions were inside or outside the scope for a couple of reasons. First, Mr. Hornibrook never argued that Ms. Richard was acting outside the scope of her duties, and even conceded as much in a reply brief in the Superior Court. And even throughout the briefing here, he's referred to Ms. Richard as the conservator. I think on that alone, the court can conclude that Ms. Richard was acting within the scope of her duties with respect to all allegations in the complaint. However, if the court were to go further and say that there was a challenge, I think a functional analysis also establishes on the plain reading of the complaint that all of the allegations were within the scope of her duties.
Can you tell
Go
us
ahead.
how from what I understand, the judge gave either pre or post approval the right to sell the house, right? And the right to have the house cleaned, right?
I don't think it was explicitly provided to be cleaned. The conservator was granted a license after contested motion practice to sell the house,
right.
which in that I assume she would need to clean it out to be able to do that. There was a motion, but it was never ruled on, or it's not on the docket to say what the disposition of cleaning out the house was.
See, I'm trying to put up the express actions taken by the judge versus what the express actions taken by the probate judge with the conservator compared to what the claims are. From what I understand, what are your understanding of what the particular claims are? That, from what I understand, one of them is that when they sold the house, or cleaned the house, some property disappeared.
My understanding of that is the same, essentially, that in preparing the house to be sold, that some of the property within it, which were, family mementos, were also removed without notice.
Okay, and so are you saying when the judge gives the permission to sell the house, he also gives permission to dispose of the personal property in the house? Is that what the argument is? I'm just trying to understand it, because again, I've got these two claims that are left, this conversion one, which relates to that property. And then there's some kind of issue related to the eviction of Francis that I don't fully follow. But
I think
did the judge give express permission to evict Francis?
not in this. So the conservator hired an attorney to have Francis evicted. So
Right.
that's somewhat separate. I think more the issue here is whether the actions which the conservator took related to the sale of the house, either pre or post the license being granted, are within her duties as the conservator. And because if they're within the duties, then there is immunity for those actions.
So let me
Is
give
it
you a
really
hypothetical. One last question. Let me give you a hypothetical.
Sure.
When she, and this isn't this case, when they clean out the house, they discover all of the mother's jewelry, and it's worth a lot of money. And the conservator takes the jewelry and keeps it.
Mhm.
Would she be protected from if she did that?
I think she would be protected from tort claims, but I'm not saying there's no remedy at all. We have plenty of remedies within the probate courts, such as surcharge, removal, indemnity. We have the probate court can deal with that in a certain way. I'm not saying that criminal actions are also barred by this immunity. And, you know, even if this is an attorney, not every conservator is an attorney. We also have things like the BBO and remedies there in a professional capacity. So it's not that there's no remedy, it's just the remedy is not the civil tort claims that the plaintiff is bringing in this case.
Counsel, may I ask you, perhaps I'm missing the threshold issue. Is your position a Rule 12 issue, or is it really getting to the meat of whether there's an immunity or not? Because if it's the conversion issue, what I'm struggling with is that the court found that the allegations of the complaint were sufficient to survive a Rule 12 motion, that they pled things that were outside of the scope of the immunity to the conservator, even if we assume that there was one, particularly this conversion issue. So is it really about whether or not immunity applies, or is this really about whether or not the judge was wrong that the factual allegations met the Ian Keno standard? That's what I'm struggling with.
I think it's a little bit of both. So the heart of this case is with respect to immunity and whether the court-appointed conservator is entitled to immunity for actions taken within the scope of their conservatorship. And I think
If that were pled, if the allegations of the complaint were that all of the things that they complained about were things that were within the scope of the conservator's authority, but if it's not, if they're alleging things that were outside of the scope, why is that about whether or not the immunity applies one way or the other, and not just about whether or not it's properly and sufficiently pled?
Well, I think answering that in two ways. So first, with respect to the decision of the Superior Court, I think their decision is conflicting and I can't reconcile it, which is part of the reason why we appealed. On the one hand, they say that the conservator is entitled to quasi-judicial immunity, and then sort of gave the plaintiff, you know, sort of some leeway, to explore through discovery in a brief amount of time whether the actions were outside the scope of her conservatorship. However, there had been no suggestion by the plaintiff that any of the actions were outside the conservatorship. And on top of that, the decision actually doesn't point to anything. It says that it's giving Mr. Hornibrook, you know, may find. He hasn't pointed to anything that there is any allegation outside. And I think at the motion to dismiss stage, this is the time we need to do that evaluation. The court has everything before it that it needs to. It has the allegations in the complaint, and then it can have the court appointment and the duties of the conservator as well. That's usually an order of the probate court. So it's either attached or referenced in the complaint, or otherwise it can be taken in judicial notice. The purpose of quasi-judicial immunity, we want to get these out at the beginning. It's litigation immunity, not just damages. So to allow this when, particularly in this case, where there was no allegation that.
Well, I understand that the conservator doesn't have the protection if they have to go forward with the lawsuit, because the immunity, as you say, is an immunity from suit. But implicit in the Superior Court judge's decision is that some of the allegations obviously fell beyond the immunity issue. And the question really is the specificity of the court order under the Cox versus Constantino case. Don't you think so? Doesn't there has to be some specificity that's tied back to the court order? I think that was the thrust of Justice Kafka's initial question.
And I think that's right. And I think in this case, it's clear without an allegation from the plaintiff that everything was outside, and then actually doing a functional analysis, which I don't think was done in the Superior Court decision. I think this case falls clear that everything was within that scope.
Counsel,
What
with
about the
regard to,
statute?
go ahead.
Go ahead, Justice.
No, I was
Sykes.
just going to ask about you said that in your brief that the proceeding to discovery abrogates the doctrine because it deprives the conservators of absolute immunity. But we use a functional approach. So wouldn't any functional approach require us to examine, to perhaps permit discovery in some cases?
I think there could be some cases where it's not clear on the face, but in this case, it is pretty clear on the face. You have the complaint and the allegations, and you have the conservator's appointment. So you can compare those at the motion to dismiss stage. And in this case, it's pretty clear that the biggest thing of this complaint is regarding the allegation of the selling of the house, which was particularly before the probate court and approved in a motion after disputed motion practice. So in this case, I don't know what discovery would even show. Actions are within using the property of Ms. Hornibrook, which is something that is within the scope of her conservatorship. And then we have the.
But before you get there, though, that's the part I'm getting about the conversion. Assume that the order was you can sell the home. Are you saying that implicit in that order is you can get rid of everything that's in there in preparation for it without any regard to the rights of the beneficiaries or the family of Ms. Hornibrook?
The conservator almost acts as like a trustee for the conservator, the protected person. So she has the property, essentially in her possession, in her name, and she can do with it what is appropriate. And if there's an issue, it's not that it goes to the Superior Court for tort damages, but instead we're going to the probate court where there's other remedies that are available, such as, removal or accounting or surcharge. There's other remedies, it's just not here. And in reviewing this, I think it's pretty clear that all of these actions were within the scope of her conservatorship.
Okay, counsel, I have one more question about what you said the home was in her possession.
Mhm.
But she didn't even know it was being foreclosed on. How does she explain that?
I don't think that's completely before the court. I mean, she did.
Would that be part of the discovery?
I mean, the allegations in the complaint so yes, seems to be a part of the complaint, as it is part of her role as a conservator to have the property, and it almost be like a trustee that she's entrusted of the protected person's property. Yes, some of that inquiry is there, but it should be in the probate court. The probate court is the one that has issued these orders. The probate is the one that has the specialty who's been involved in this process. The probate court has granted this license to sell the house. The probate court is intimately, involved in this process. To sort of remove it from that, where the probate court has already issued orders relating to.
I thought you removed it. Didn't your client move it to the Superior Court?
No,
It was the other way around?
This started out in the probate court,
Right.
asserting civil tort damages. We've always said that the plaintiff could have brought these remedies in probate court, just that the civil tort damages couldn't be brought in probate court. If you're bringing those type of claims, they need to be in Superior Court.
Mhm.
So then the reverse is that, it's appropriate for the probate remedies to be brought in probate court.
Got it. I think Justice Capper has a question.
Can I ask you to interpret this statutory provision for me, 190B 5-428B? So we've got this thing that's entitled personal liability of conservator. The conservator is not personally liable unless the conservator is personally at fault for either obligations arising from ownership or control of property of the estate. So again, when we're dealing with this conversion claim, okay, they allege that property was improperly disposed of. Doesn't that fit within B? Why doesn't that fit within B? I understand it may be too generally pled, as Justice George points out, but again, if it were rings, diamond rings or something like that, that she took or threw away, why doesn't that provision cover that?
And my understanding in reading the statute is that sections A, B, and C relate to claims against the conservator as respect to third parties.
I understand you argue that, but the language doesn't say that expressly. Are any cases, do you have any cases I can read? Because from what I understand, there's this Alaska case that goes the other way. Are there any cases that support your position?
Not that I know of here in Massachusetts. And I think
How about all 50 states? I'll ask you the Justice Gaziano question. Other states?
that I am not sure of.
Okay, so how do I decide those provisions which on their face aren't limited to third parties or limited to third parties then without any case law guidance? Is there any legislative history that I can turn to that says it only relates to third parties?
With specifically that point, no, not that I'm aware of, but I'm looking at section D, which specifically addresses liability between the estate and the conservator personally, which seems to be more specific to this type of a claim. And Mass General Law section or chapter 190B, section 5-428 is derived from the Uniform Probate Code. And the Uniform Probate Code is section 5-430. In their comments, they generally say that their intent is to limit the liability of conservators and to protect the conservator. So in that way, I think that's why it relates back that yes, the probate code does allow for some remedies, but the remedies are limited to between an estate and a conservator in section D and are limited more to the probate court. And the reason why it should be in the probate court and must be interpreted as to section D in the probate court is for a few reasons. Mr. Hornibrook has relied mostly on that section D to say that other appropriate proceeding or action allows this action to proceed in the superior court rather than the probate court, but this can't be the case. First, the canon of statutory construction, justum generis, provides that the specific words identify the class and restrict the meaning of the general words that come after in the class. It would be inconsistent to find that the first three items in this list, which are probate remedies, allow for the fourth to be something so much broader, such as an action superior court. In addition, looking back to the probate code, it expressed an intent to narrow the liability of a conservator. So to follow that same rationale, and it's more important to have this as a narrow construction of the statute. It's long been held that statutes should not be interpreted to
I'm going to stop you there. Thank you very much. This is very helpful. And we're going to move on to Attorney Stiles.
Thank you, Chief Justice and Justices, and may it please the court. I'm Ethan Stiles, and I represent Kevin Hornibrook, who is the personal representative of the estate of Kathleen Hornibrook in this case. And let me start by asking, is a protected person under guardianship a person or a passbook? And the conservator made her views on that very clear when she said, you can move your mom back in the house and deal with your drug addict brother. My role is a financial one. But the Massachusetts version of the Uniform Probate Code says something quite different in section 5-416, where it encourages and requires conservators to help the protected person regain and participate in the management of their property as to the extent that they can. So in this case,
I'm confused because your clients are guardian. So aren't you imposing the guardian responsibilities on the conservator? And it just seems like you're merging different obligations here. But can I turn you to specifics, particularly Justice George's question, what do you allege specifically on this conversion? Because she has permission to sell the house. To sell the house, you need to do some cleanup of the house, particularly if it's been occupied, in sort of a messy way. So tell me, what are you alleging that is beyond her power to sell the house?
Well, in terms of the personal, in terms of the personal property inside the house, her whatever she has to do does not come to what she actually did, was to simply let the pickers go in and take what they want and trash the rest. And that's what we allege happened in this case.
So
And
in
then-
your can you read what you say in your complaint? What did you say on that point? You alleged what? Because just saying there's a bunch of goodies in there isn't helpful. Do you allege that? Read what your allegation is on this point.
I don't have the specific allegation in front of me, Justice Kafker, but I do remember quite specifically that I did state that the people who came in took everything out and would not let my client or his sister take any family mementos or keepsakes.
And are you alleging that that occurred outside her function as a conservator? And
yeah.
where do you allege that? Because it seems to me you've conceded that everything that you're alleging here is within her function as a conservator.
Well, Justice Wendland, you could look at it two ways. You can either say that this was outside the function of a conservator because she is a fiduciary for a property, both real and personal, or if she was acting technically within the scope, she's still liable under Section 5-428 for this.
No, I guess let me be clear. Where specifically do you allege or contend that she is acting outside the scope of her conservator?
By the allegation that she permitted the property to be taken and destroyed. That is an allegation that is outside the scope. Well, the term outside the scope may not be used in the complaint as such. It's quite clear that, as I allege it, that this activity was either outside the scope or which she is liable for.
So what paragraph of the complaint are you referring to?
The paragraph of the complaint would be whichever one talks about cleaning out your house. I don't have the complaint in front of me. Perhaps I should have had it, but anyway. But when I talk about the paragraph that references the cleanup company called Clean Out Your House, Inc., that's the paragraph in which I refer to the actions of that company, hired by the conservator, and also in the count that discusses the conversion claim.
Okay.
So anyway, now,
Counsel, may I just follow up for one moment on some facts? And that is, you said that the pickers came in, and this is Clean Up Your House, the Clean Up Your House Inc., the pickers?
yes.
Okay, and then when they picked what they wanted, did they buy it from and pay for it? Or
No.
what happened to the quality items?
I don't know, and that
So
would
no
be
money
something-
went to this, no money went back into the estate from that?
Nope, not a penny. In fact, and Clean Up Your House, they have an invoice which is not in the complaint, but it is. That's how that allegation alleged, but says that they can take what they want and dispose of the rest.
Mr. Stiles, in response to Justice Wendland's question, you referenced the statute, Chapter 190B, the Section 528, and the language, other appropriate proceedings. The conservator just argued that that provision is limited to remedies in the probate and family court and doesn't give you the opportunity to litigate in the superior court. Do you say that language from the statute? Why isn't it limited to the probate and family court based on her statutory construction argument?
During my sister's presentation, she referenced the Uniform Probate Code, Section 5-430, from which Massachusetts 5-428 derives from. And there is a comment in there. She didn't. What she didn't talk about, and the reason why is quite clear, because it says, quote, "The protection from liability provided by this subsection does not apply, however, if the conservator is personally at fault," meaning the conservator committed the tort either intentionally or negligently. And that comment speaks to what these words are derived from.
Can I ask you to read that again slower?
Yes, of course. Quote, "The protection from liability provided by the subsection does not apply, however, if the conservator is personally at fault, meaning the conservator committed the tort either intentionally or negligently, end quote. And so I would suggest that Massachusetts, having derived that, using the exact same language in that in subsection D, is again expressing the intent that, that yes, conservators are liable for negligent acts. And let me talk about the home, because I feel that there is some confusion of what the gravamen of our complaint is on that count. When Richard was appointed conservator, she started her conservatorship ineptly and ended indifferently. And the inept action was to try and get Francis out, the drug addict brother Francis, out of the home. She tried to change the locks, engage in self-help to evict him. He came, he threatened her, she left. And then for over a year, she did nothing. But she kept promising my client, Kevin, that she would get her out of the, get him out of the house. And she did nothing for a whole year, for 2015. She kept making these promises via text messages, which she outlined in the complaint. And then in 2016, Kevin learns that, that the property is up for a foreclosure auction because his mother had been out of the house for 12 months, which was a requirement of the reverse mortgage covenants. And so at that point, he calls the conservator, and that's when she makes the quote I mentioned at the beginning about my role as a financial one. And after that, then she had to go and obtain counsel to get an emergency motion to restrain the home.
So what is your claim on this, that she did not evict Francis fast enough? Is it, or that she, I can't, what is the claim? What is the alleged violation on that point? I understand your conversion argument that worthwhile property that she should have preserved was allowed to be walked off with. I don't understand this one about Francis yet.
My argument is that she was grossly negligent in failing to evict Francis and restore Kathleen to the home in a timely manner, and as a result, she lost the home.
So what claim does that fall under in your complaint?
That would be the breach of fiduciary duty claim is the most applicable one, because conversion applies to personal property, not real property, so we have to use another source to do it.
So as a conservator, she did not, again, I'm trying to understand what is within her responsibilities as conservator and how she violated it. So it is within her responsibilities or not to evict Francis and put mom back in? Is that a conservator responsibility or not?
I mean, and first of all, the conservator has control over the property of the protected person, as opposed to the guardian, who has control over the person. So it is ultimately the conservator who's going to decide where she's going to live if she can't live in her own home.
That allegation is within her function as a conservator, is what you're conceding. It may not have been done appropriately, is what you're saying, but it's within her function.
Yes,
Okay.
that she does have that. She does have that power and control as a fiduciary of her property.
Really?
And in this case,
she has that. She has control to, okay, all right. I mean, any cases that say a conservator has that power?
there is a stat that what it is in the powers in section 5. I can't remember. In 5, it specifically says that she has title to the real property.
I know, but there's also a guardian. There's a guardian in place over mom, right?
That's correct.
So the guardian, I'm just trying to understand what are the guardian's responsibilities versus what are her responsibilities? Because her responsibility is to preserve the value of the house. It's not to make sure mom is well cared for. That's your client's responsibility, wasn't it?
In this particular case, not so much, because in order to preserve the value of the house, Kathleen had to be in her home to do so. Otherwise, it goes to foreclosure. So in this case, she did have a responsibility to evict, and she's the only person who can evict. A guardian cannot evict the drug addict brother. He doesn't have that authority. He has authority over the person, of the protected person, not her property. The conservator does that, and in this case, she volunteered for the job when she was first appointed. She heard about the plan. She said, yes, that's a good plan. I'll take care of it. I'm going to evict the brother. And the only action she took to evict him was illegal, frankly, and certainly malpractice, and if the judge dismissed that part of the complaint. So anyway, and
You're not appealing the dismissal of the malpractice claim.
we cannot at this time, as
Yes.
that's an interlocutory
Right,
issue.
so that's out.
But still, she was an attorney, and Mr. Hornibrook is not an attorney. So if she says, I'm going to take the lead on this, and that's what she kept saying that she would do for the next year. And in the meantime, she's over the 12-year limit. The mortgagee wants to foreclose. And by the time we get to the license to sell, at that point, the judge it's no longer just a question of, can Kathleen move back into her home or not? And whether the conservative thinks that selling it's better than Kevin thinks that being in the home would be better. Now we've got the rights of a third party who's come into the situation and says, violation of the mortgage covenant. I want to foreclose. And so it had to be sold. And which brings me to the question does the license to sell forgive all that's come before? And I would suggest that it is not. It is not. It wouldn't be any different than if the conservator let the homeowner's insurance lapse, the house burnt down, and she had to sell and she got a license to sell a vacant lot. Does that eliminate the negligence of letting the insurance lapse? It should not. And that brings me to the reasons why this court should allow this case to continue. Is because ultimately, when the amicus letters talk about, oh, this is going to discourage people from serving, they've never had any kind of respite from negligence. And more importantly, if the conservator gets carte blanche to do whatever they want without any real recourse to the protected person or their family or their loved one, their estate, then people are going to be rather cagey about raising issues that could result in the appointment of a conservator if they think the conservator has carte blanche to do whatever they want and without personal liability to the protected person. And the remedies, now when we filed this case in probate court, and it was the defendants, my sister's firm, who tried to have it dismissed, and they argued the probate court has no authority to give money, to award money damages in this case, and the probate court judge bought that and transferred it to Superior.
Did he do it correctly? You say he bought it. Did he do it right? I mean, was it the right thing to do?
I'm not sure. I never agree with the motion, but if that was one way we're going to get this thing resolved, then that's fine, because the Superior Court is a court of general equity jurisdiction, and it also has the ability to try tort cases, and it can try them by jury, whereas the court does not. However, I would suggest that either court would have been appropriate, but we're appealing the order of a Superior Court judge, not a probate court judge. And so ultimately, this game of jurisdiction has been going on for 3 years, and the conservator has yet to even file an answer to the complaint. And so ultimately, we're asking this court to remand this back to the Superior Court for discovery and for the proceedings. Thank you.
Okay, thank you so much.